Good afternoon, Judge. My name is David Grimmett. I represent the appellants, the Helmlingers, and Ms. Chapman. I'd like to reserve 5 minutes for rebuttal, please.
5 minutes, yes, sir.
Your Honors, this case is a rather contentious and long case, considering it's been going for 7 years. Would you like me to provide a brief recitation of the applicable facts?
I'm going to let you decide how you want to use your time, but you can be assured that the panel has read the briefs.
Yes, sir. I thought you had, and I just wanted to make sure, just for oral arguments purposes. Primary issue in this case is abandonment, and what is the defense to that case? Originally we alleged 2 different grounds for termination, and both are under abandonment. The first ground was the failure to manifest an ability or willingness to assume legal or physical custody or financial responsibility for the child. Second ground was 4 consecutive months willfully failing to pay child support. In this particular case, we tried this case over the course of approximately 4 days, and we heard multiple witnesses. But the ultimate issue is, did the father willfully fail to pay child support? Your Honors have probably read the judge's order. She wrote a very, very long order in which she went through every single witness and she gave her expert analysis. Here's the problem. She said that technicality is not enough to terminate somebody's rights. But here, that's what the law is. When the law says that you must pay child support, whether there's an order or not, that is not a technicality.
Counsel, what does willfully mean here? How should the court understand willfully?
Excellent question. The ultimate, and I've looked at some of the case law, and I've dealt with this type of situation multiple times. You have to look at all the circumstances surrounding it. You have to, just like the judge did, and you have to look at what exactly did they testify to? What was the reason that they gave? What was the reason they gave for not paying? And here, the father testified very specifically on cross-examination. And that's in volume 2, found at page 30 through 31. Specifically, I asked him on cross-examination, question, yes or no, you would agree with me that you did not pay in November 2020? Answer, yeah, agree. Question, and you would agree with me that you did not pay in December 2020? Answer, agree. Question, and you would agree with me that you did not pay in January 2020? Answer, agree. Question, and you would agree with me that you did not pay in February 2020? Answer, agree. And you would agree with me that you did not pay in March 2020? Answer, agree. And you would agree with me that you did not pay in April 2020? Answer, agree. So we know that he didn't pay, but it goes.
Counsel, when was this petition filed, in 21?
Yes, Your Honor. It was filed specifically.
And the willfulness was not raised as an affirmative defense in the response here, was it?
That's correct. In fact, they raised a few affirmative responses. They raised unclean hands, I believe. And then in opening argument, the judge or the opposing counsel did say, oh yes, he did pay. We have the checks to show that he paid. But then we did further discovery, and we learned that he had actually backdated the checks.
Well, I mean, I guess my question is why was willfulness in the discussion at all here? Was that issue tried by consent? Because that is not part of your burden in the case. I mean, isn't willfulness an affirmative defense on that ground of abandonment?
Well, and that was a question we were trying to figure out at the time, to figure out which law we were supposed to use as far as the petition being filed, because as Your Honors might recall, they changed the petition to shift the burden as far as willfulness goes. So I think to a certain degree we probably tried it by consent as far as willfulness goes. And ultimately the question was, did he willfully fail to pay child support? And going back to the testimony, again, he admits that he did not pay it. There is no question. He did not pay the child support.
The trial court, correct me if I'm wrong, the trial court had a sense that there was confusion here in terms of what he was supposed to do, when he was supposed to do it, and as the trial court essentially says, this has been a Byzantine process. It's gone on for 7 years. At this point, he doesn't know exactly what he's supposed to do. Is that enough to defeat willfulness then?
Well, that's an excellent question, because if it is, then I need to know about it, and I think the juvenile court bar needs to know about it, because that means that any time that I, as the respondent, win a proceeding, does that mean that my client, from a subjective perspective, does not have to pay child support? Does that mean that if we agree for a child to go into DCS custody based upon their own behavior and not based upon the allegations contained in the petition, does that mean that the parents no longer have to pay child support? Does that mean that every time I win any kind of motion in a dependency and neglect petition or a TPR petition, does that mean the respondent no longer has to pay child support? Because that's exactly what happened here. In this particular case, the father won the juvenile court, or won the proceeding down in Florida. And he testified, oh, now that it's over, I don't think I have to pay child support. And now I've received this letter from opposing counsel for the mother that says it's over. That must mean I don't have to pay child support.
And the father is making significant expenditures at this time in terms of preparing for the child to come in. He's buying washer, dryer, he's buying bedding, and there's significant expenditures that are being made at this point.
Absolutely. However, under Tennessee law, child support is not for the person taking care of the child. Child support is for the child. And yes, and that's under Kirkpatrick versus O'Neill, which is a Supreme Court case of 2006. And the reason why I bring that up is because we have this happen all the time. Father claims that he did not have an order telling him to pay child support, but he still continues to pay child support. Under Tennessee law, even if you don't have an order to pay child support, you still must pay child support. And that has to be support for the child. Were those expenditures for the child? Maybe, if they were in his custody. The child was not in his custody. The child was in the Helmlinger's custody. Therefore, there was no child support for the children. Let me also...
The father won the case, but the father did win the case in Florida. Then as a consequence of that, to whom was he to pay support?
Mother. And his attorney, his Florida attorney, has consistently, I say consistently, but has paid the checks directly to me as mother's attorney. And I've deposited them into the trust account so that we can keep a record of that. And in this particular case, let me also go into this. We alleged two different grounds for abandonment. The first one was the failure to manifest an ability to basically take care of the child. Second one was the willful failure to pay 4 months. We are conceding the first grounds. And the reason why that is because why the judge dismissed it in the first place. The judge said he's been fighting all these years. He's shown an ability to manifest custody for the child. That is the defense for the first grounds. The judge's analysis was improper for the second grounds. The judge's analysis should have looked at that testimony where the father was questioned and said, question, and you certainly had the ability to pay. Answer, yeah. Question, and you knew you had to pay. Answer, yeah. He knew he had to pay, he had the ability to pay, and he still failed to pay.
Is there another pending petition to terminate?
Yes, there is.
Okay.
In fact, what's odd is that now, after the father won, he again has stopped paying child support. He submitted a affidavit in his support of summary judgment, and it says something along the lines of, "I did not want to pay."
So when was the new petition filed, and what's its status?
Let's see here. The current status is we filed it approximately September of 2022. They have filed a motion for summary judgment, and I'm about to file a response to that, basically saying that if his affidavit says he did not want to pay, that shows willfulness. Therefore, it should go forward. One other thing is that, of course, best interest. We put a lot of emphasis on best interest. The judge did not go into best interest because she did not find grounds, which is fine, because typically you should not go into best interest if you do not find grounds. We would ask that if your honors do reverse it, to at least do one of two things: allow us to supplement the briefs to discuss best interest, or two, remand it back to the trial court to determine best interest. As far as the
Is
current
this-
step,
Is this particular judge still on the bench?
yes, it's Judge Guffey out of Williamson County.
Okay.
And as far as the petition for termination, that was filed in Chancery, and that's going to be heard before Judge
Well,
Johnson.
I mean, the problem with that argument, counsel, is that there's case law from our court, and looking at a Supreme Court case that says that in a PT or termination case, we can't soldier on and look at the record ourselves and do certainly that sort of analysis for grounds. I don't know how we would do it for best interest. I mean, I don't know how we get past that.
And past the best interest.
So, I mean, what we're looking at here is if we agree with you, vacate this dismissal, send it back, you've got 2 termination cases pending.
Correct. With different grounds.
And different 4-month, 6-month relevant
Correct.
period.
And I see my time is up.
You can answer the question.
As far as the two, there is some case law determining which specific period to use. I believe it's, and I think I might have cited to that in my brief, because I think I've tried that case in front of the Court of Appeals when we tried to figure out which case period to use. Here, we have 2 different case periods. And why is that? Because the father has chosen to not pay child support. At what point do we need to say, Father, pay child support, or your rights will be terminated? I'd like to reserve the remainder of my time
Thank
for
you, Mr. Grimmett. We'll hear from the appellee. Good afternoon.
Behalf of Mr. Wade. Ms. Crystal Etu, the guardian ad litem, is here, and to please the court, I'd like to defer 6 minutes to her.
All right, so you're going to use 9.
Yes, if
Very
that's
good.
okay.
Thank you.
This is I see this as somewhat of a unique case.
And you represent the father.
Yes, I do, Mr. Wade. In that, I tend to read cases that come out of this court every night, and I see a lot of termination cases. And it seems as though this case is somewhat opposite from a lot of those cases where we have parents who simply abdicate their role as parents, and after they've done that, they then come back before this court and say, hold on, don't terminate my rights. Well, Mr. Wade has been fighting for his rights since the child was born, 7 years, and we're still litigating the case.
But why did he stop paying?
Well, he explained that when he received that letter in November of 2020, he believed the matter was over, and as a result of that, he was like, well, I'm going to be getting my son. And as a result of that, he began getting things for his son. And so in his mind, that was the explanation.
But in the interim, someone else was having to support the child.
Right. Yeah. There's no dispute about that. But when I look at these other opinions that are authored by this court, it's often, well, there may be an issue with this ground, but we've got these 3 other grounds that exist, and therefore it doesn't really matter. But when it comes down to it, the issue here is the court saw it as more of a technicality, and under the circumstances of this case, she was unwilling to find that it had been proven by clear and convincing evidence that he had willfully failed to pay.
In some senses, the grounds are technicalities. I mean, certainly with the definition of abandonment, the legislature has selected an arbitrary period of time and defined that as abandonment. So how could we just ignore the legislature's chosen, I mean, may not be the best indication of whether or not abandonment truly happens, but that's the way the legislature has defined abandonment. So aren't we compelled to follow that definition?
Well, at first blush, I think isn't that the critical case here? Isn't that what the issue is in this case? Is 4 months of non-payment, your rights are terminated?
No, that's the important consideration here. The mere fact that he may be found to have abandoned the child for failing to pay support does not mean his rights will be terminated. You go into the best interest. So this technical requirement that he pay support during a specific 4-month period is a ground for termination, but it does not mean that his rights are going to be terminated on a technicality, because we're going to consider 9 other factors, if not more than 9 factors, depending
Right.
upon the time frame of the petition.
Understood. As far as it, and then of course it would need to be remanded back to Judge Guffey, and then we get into the situation where we've got this other matter that's pending.
So as Judge McBrayer has indicated, can we ignore a technicality? Did you willfully fail to pay support during the relevant 4-month period?
And I guess it comes down to willfully, which is what you asked Mr. Grimmett when he came up. What does that
so counsel,
term
what makes
mean?
this then not willful? And opposing counsel says it is. You're, I presume, saying it's not. Why is it not willful?
Mr. Grimmett said, you didn't pay when I asked you under oath if you paid or not. You said I didn't pay. Well, he testified under oath why he did not pay, and he explained that. The question is Judge Guffey found that his testimony was credible.
But counsel, following up on Judge Clement's question, he knew the child wasn't in his custody at this time. Somebody's taking care of him. Somebody's putting food in this child's mouth, keeping a roof over their head, and it's not him. And so what I'm trying to understand here, what makes that what's the confusion, what's the uncertainty, what's making it not willful? I mean, he may have thought he shouldn't have to anymore, but
I don't think it was that. It was, hey, this matter is now, we believe this matter is now over. His anticipation was, I've got to get ready for my son to come live with me because he's coming now.
And is that a misunderstanding as to whether he has a continuing obligation to pay child support?
I think it is a misunderstanding about what he expected to happen shortly thereafter, after he got this letter.
So would the record reflect that he thought he was going to have custody of this child sooner?
Absolutely. Yeah, the idea, and if you think about it, he's fought this battle since this child was born, and for him to, at this late stage, just say, well, I'm just going to stop. It makes absolutely no sense for him to do that under the circumstances, considering all the resources and time that he's put into this battle. And so, yes, he believed at that time that he was going to get his son, and he changed from paying that support to getting things in anticipation of receiving his son. And that's exactly what happened. And that's what Judge Guffey determined in this case. And she found there was no evidence that he willfully did this under the circumstances. And yes, it is a technicality, but I think Judge Guffey was trying to work through that, in her opinion, after all the testimony that she heard. And this is not a pleasant case. This is not. This child's and this father, they've been in limbo for 7 years. And
So
it looks like
the judge in the order says 2 things that line up with the affirmative defense. Well, at least the affirmative defense is, as described in Ray adoption of Angela E. She says, was he, father here, intentionally not paying child support because he was giving up and abandoning the child? And the court answers the question, no. I mean, it certainly sounds to me he made a conscious choice here. It was intentional. Then the other thing she finds is, if there ever was an instance of having a justifiable excuse for not making his monthly child support payment during this turbulent, legally complex time, this is it. So help me understand why this is a justifiable excuse for not paying child support.
When he received this letter in November of 2020, he anticipated getting his child. And his view was, if I'm getting my child, then I need to put resources toward preparing his arrival And if I'm getting him, then I don't need to be paying someone else because I'll be
Counsel, one thing I
providing.
have a hard time with that, though, is the opposing counsel went through a series of didn't pay in this month, didn't pay in this month. He knows somebody's having to pay to support this child. Now, he may be anticipating it's going to be next week, it's going to be in 2 weeks, it's going to be in 3 weeks. But when that first month passes, the check doesn't go in. If it had been weeks late, but had gone in, here it doesn't go in at all, and it doesn't go in at all for 6 months. And so, and he knows that somebody's been caring for the child during that time period.
And I think it's important to note that those payments were made after he realized, you know what, there's another barrier here. My son is not coming. Then those payments were made. But at the time, you know, we can only go back and go, well, what was he thinking at the time to determine willfulness? And here, I think the court took the position that the appellant in this case had not proven by clear and convincing evidence that it was willful. And I think that's the issue for this court, is was she wrong or was she right? And if you say she's wrong, I guess you'll remand it. If you think there's not enough to overturn it, then we have another battle. This litigation will go on another 2 or 3 years, and we will likely be back in front of you.
We'll be here.
I know.
Thank you, Mr. Freeman. All right, Mr. Grimmett, your rebuttal. Oh, forgive me. You're absolutely right, and I apologize. I'm on autopilot here. My sincere apologies.
Good afternoon, may it please the court. I am Crystal E2, and I was appointed as guardian ad litem for Preston H. So, Your Honors, Mr. Grimmett offered to go through a procedural history of this case, and as the guardian ad litem, my position was a little bit different in that I have to look at this case from a different perspective, and I have to look at what is best and what is the right thing for Preston. And it wasn't until I actually was able to examine the complete and comprehensive history of 7 years, 3 states, and now today 7 different courts that this litigation has been going on. The record will show, or the record shows, the proof shows that the Helmlingers and mother knew before Preston was born that Mr. Wade had no intention of giving up his rights. He filed with the putative father registry. He did everything right. Then when it goes all the way to the Ohio Supreme Court, gets reversed in favor of father, then shortly thereafter, mother files in Florida. That case goes on for years. There's a guardian ad litem in that case. There's a transitional specialist that has been appointed in that case. Only, again, to have that petition to terminate be denied. Now, mind you, all the time, Preston is here with no opportunity to even get to know his father. Not really. And we talk all the time, and we see in all the cases that the opinions that you find judges render to us, and how a parent has a constitutional right. It's a fundamental, inherent constitutional right to parent their child. Well, what about the child's inherent constitutional right to family integrity, to know where they come from, to be parented by their biological parent if that parent is fit, able, and willing to parent? I understand the 4-month period. Now, one thing I think is important to note, if you look at the timeline of this case, June of 2019, the Florida court denied the Helmlingers' petition to terminate, my mother's petition to terminate. And then throughout the time before it got here, there's fathers filing a second petition to establish paternity. They're going through this transitional specialist. COVID hits, which obviously complicated a lot of things with regard to visitation. Father has maintained as much visitation as he possibly was able to. And this is the interesting part. December 22nd of 2020, biological mother filed a motion with the Florida court for a psych eval of father. It was denied. January 29th of 2021, it was denied. February 16th, mother files a expedited motion to temporarily relocate to Tennessee because she knows that now she's going to resume custody. Mind you, this child has never been in the physical custody of the biological mother, ever. This child's last name is Helmlinger. Which is not the last name of either the mother or the father. She filed this expedited petition to relocate, or motion to relocate, and then literally a week later, they file a petition to terminate here. So at the time, in the period of time that father wasn't paying his child support, he's still in full litigation in Florida. So Tennessee law is specific to that 4-month period. In Florida, I don't know what the Florida law is, but I don't believe it's 4-month period.
So that's justifiable excuse, you would say?
I just believe that, Your Honor, so there's case law out there in Re Alicia S, which is 460 Southwest 3rd, 536. It says that we recognize that the statutory definition of abandonment requires us to focus on the period of 4 consecutive months immediately preceding the filing of the proceeding. However, in determining whether the parent's conduct was willful, it became necessary to evaluate the events occurring prior to the start of the 4 months. It also goes on to say that the courts often consider events that occur prior to the relevant period to determine if there was interference with the biological parent's attempts to visit or support the child. Now, granted, there's not necessarily an interference with father's ability or to pay support. However, mother and the appellants created this situation.
Counsel, is part of the 4-month time period this mother's still in Florida pre-move to Tennessee? Part of the 4 months they're being counted?
Yes.
Okay.
Yes, Your Honor. In fact, most of the 4-month period, she was in Florida because she did not file her expedited motion to relocate until February 23rd of 2021. February 16th of 2021. The petition to terminate was filed February 23rd of 2021.
Have any due process issues been raised in connection with application of Tennessee's 4-month time period? Given that mother wasn't a resident of Tennessee, I have not looked through all the filings in this case. But
there was a UCCJEA conference that was held prior.
And the Florida court did say Tennessee should have jurisdiction.
They relinquished jurisdictions because the child has always been here. But that's difficult to explain to a layman when litigation has been going on in Florida for multiple years. And I realize that I'm out of time, and I did not yet get a chance to address
well, and we know,
right?
We know you got, and good for you for focusing on the child here.
I just felt that was more
the
important.
court is mindful of that, and we've also absolutely, and we have read your brief on that. We're well aware of the arguments. But let me ask you, I want to get your impression on that justifiable excuse. I mean, I'm wondering about the precedent this case might say if we say, I'm trying to figure out how you describe, because the court really doesn't say specifically what the justifiable excuse here is. It the end of being in midst of litigation that's a justifiable excuse? I mean, that's not really the fact here. It had actually ended, and father feels like, I'm not going to have to be in court, but clearly that was a wrong assumption.
I think in line with Your Honors, in line with what Mr. Freeman was saying, father had made, he received this letter from the appellant's, not the biological mother, but the appellant's attorney, and saying, hey, our path to adoption has ended. You need to start communicating, because the biological father was pursuing custody and parenting time. Said, you need to talk to mother's attorney. And so in light of that, he starts to purchase, what I would consider necessaries. If he's about to have time with his child, then he has to purchase those things that are necessary to care for that child.
That's an interesting argument. Unfortunately, that's not the finding the court made. The court didn't make the finding, well, I'm going to count these necessaries for the child as support during the 4 month. I mean, the court went out and said, I find, and father conceded, he made no payments during the 4 month period. So had that argument been made, that might be more compelling, or the court made that finding, but the court didn't. So we are left with this idea: was the affirmative defense proven by father here, and he had the burden on that. And I'm
at what point, though, Your Honors, and I'm just a question: at what point does
this need to stop?
Yes, and the appellants have thwarted every effort and delayed every chance they can for this man to be a father to his child. And I think that in the court, I may be going out on a limb saying this, but this is a relevant issue as far as I am concerned. This child is biracial. Father is African American. The appellants are Caucasian. This child needs that guidance on how to grow up in this country being an African American male. Something that father desperately wants to be able to provide to his child. I know that doesn't necessarily speak to the 4 month period, but I think that there are a lot of mitigating circumstances in this case, and the fact that it has been litigated in 3 states. When they filed their petition here in Tennessee, there was still active litigation going on in Florida. So I would imagine father was probably confused too as to what he should do. And, mother filed her petition to relocate, stating that she was coming back to Tennessee to assume primary care of the child. That is in her pleading. She never once assumed primary care of this child. This child has never been in mother's physical custody.
All right. Thank you, Ms. E2, for your argument. Thank you.
Thank you, Your Honor.
Mr. Grimmett, your rebuttal.
Yes, Your Honor. Perhaps what the child needs is a father that's willing to support the child. This father chose to not support the child. This father chose to not support the child for 4 months. They're claiming that's a technicality. Your Honor has hit the nail on the head. The law is not a technicality. The law is the reason that we follow things. The precedents are the reason that we follow things. If Your Honors find a justifiable excuse, honestly, I've never seen that case where there's a justifiable excuse, unless, of course...
Well, it's not been... there's not been that many cases under the law where that they've switched the burden on that. But the statute does say it's preponderance of the evidence standard.
Right.
And the court has found it. So how does the evidence preponderate against that finding?
Against the finding that there's a justifiable excuse. The mere fact that he said that he knew about it, and the mere fact that says that he failed to do it, he chose to not pay child support. And what is the justifiable excuse? His excuse is that, I thought I had won. I didn't think I had to pay anymore. If that is the precedent, then please let me know, because I've got a lot of cases over here across the river in juvenile court that I can simply say, well, we won one hearing, or maybe the child's gone into DCS custody as a result of the child's own behavior. So that means my client does not have to pay anymore because they won.
So is there a due process problem with applying months of non-paid child support when Florida is exercising jurisdiction over the case? And reaching back to November 2021, if Florida is still exercising jurisdiction of this custody dispute into January, then is there a constitutional due process problem with the state of Tennessee saying, Father, part of the reason you're losing your parental rights is non-payment of child support under Tennessee law when Tennessee courts weren't exercising jurisdiction in November and December.
I don't think so, and I will say that's not an issue that's ever been brought up as far as the due process. But let me go through that a little bit. First of all, I believe the guardian ad litem is insinuating that we're forum shopping. Child has always been in Tennessee. Helmlingers have always had standing to file a petition for adoption. In this particular case, they did that under Tennessee law. Child was with them in the 4 months. Child has been with them for over 7 years at this point. I do not believe there'd be any kind of due process issue, considering the father has always known that he needs to pay child support. In fact, even in that testimony that I read to you, I asked him, "You knew you had to pay?" "Yes, sir." "And yet you failed to pay?" "Yes, sir." That was his choice.
Well, it does make more complicated, though, the issue of father buying things for the child that he's expecting to have custody restored on. If we've got another state's law that's applicable to a father at the time he's making these decisions as to where I'm going to spend my money, am I buying a new washer and dryer for when the kid comes to live with me? That looks more complicated if we're not under Tennessee law at the time.
And respectfully, I don't know about Florida law. I'm not a Florida attorney. But what I do know is that I would assume in Florida, as well as Ohio, as well as Tennessee, there's got to be some kind of presumption that a parent has to support a child. And here, did he support the child by buying gifts for the child at his house? If that's the case, again, please let me know, because I've got a lot of clients over there in juvenile court that can have the exact same argument. And if we're going to set that precedent, let's do it. Let's figure out what the defense is. Let's figure out what the justifiable excuse is. Here, there wasn't one. I would like some time to hear about the GAL's argument. I know we've briefed that a little bit. The ultimate issue is notice on that one, specifically whether there was ample notice as to whether we should have to pay for the guardian ad litem's fees. This is an issue that has come up in a few of my cases, and I believe it's come up in other parts of the state. Re Preston H is the only case I know, and I actually tried that case on behalf of the guardian ad litem. I have served as guardian ad litem on multiple cases. I do not believe that the guardian ad litem should not be paid. Let's get that straight. But the ultimate question is, who should pay her? And pursuant to the statute with this 371150D1, we have to look at the specific criteria. You have to have ample notice that you are going to have to pay. Question is, should that be at the beginning of the case, middle of the case, end of the case? Juvenile court chose to make it at the end of the case. We believe that it should be at the beginning of the case, because at that time we can determine what kind of involvement should we have with the guardian ad litem. Should we be involved? And this is a choice from a trial lawyer's perspective. You should know what kind of liabilities your client going to have as a result of that. I see my time is up, so I certainly, if there are any other questions, I'd welcome them.
Thank you, Mr. Grimmett,
Thank you, Judge.
Mr. Freeman, and Ms. Etu for your very capable arguments on a very important and sensitive issue. We will take it under advisement.